Looks like I'm living rent-free in your heads again, huh? I mean, if you're gonna spend your days obsessing over me, you might as well start calling me something respectable. Maybe Daddy Shizzy, or better yet, Papa Nut. Who's the grown-up here? Alright, it's me. Let's go. Call me Daddy. Yeah, that's who I am. Running your mind's like a master plan. Papa Nut, Shizzy Daddy. Take your pick. I'm overeating your thoughts while you still act sick. Call me Daddy. It's what you mean. Why you chase the crooks and I take the lead? Living rent-free. That's my name. Go ahead, say it. Put some respect on your name. Man, I'm too old. Well, here's a surprise. I'm the one with the brains while you're stuck with the lies. You act like you're experts, but here's the reality. I'm the one controlling your mental reality. So while you're out there trying to throw shade, I'm sipping coffee and you're feeling betrayed. You're mad, I got the spotlight, now it's my time. So why not call me Daddy or Papa with a rhyme? I'm the landlord and you're just the tenants. Stuck in your headspace with no end to sight, no repentance. Call me Daddy, you know it's true. You'd be lost without me, stuck in the glue. Call me Daddy, I'm holding your mind while you're scrambling, trying to find what's behind. Papa Nut, Shizzy Daddy, don't you see? You're living in my world now, I'm the VIP. Call me Daddy, just let it be. While you're trying to figure out your own identity. Oh, I see you're confused, trying to get it right. Spinning your wheels while I'm out of sight. You think you got it figured, but you got it all wrong. I've been running your minds all along. But sure, keep pretending you don't care. Keep saying you're done, but I'm still in the air. You got no choice but to bow to my name. Daddy Shizzy is here to own the game. You say you don't watch, but you're obsessed. Every word I say puts you to the test. Call me Daddy, Papa Nut, you know you should. Because I've been living rent-free, and you know it feels good. Shizzy Daddy, owning your headspace, and there's no escape. Good luck with that.
Greetings again, all you lovely people. It is so wonderful be here again with you today for a second time. We're gonna go for round two. Everyone, that is absolutely right. West Alabama, everyone, remember, hit that like button. I always need coffee money. It helps keep the brain from freezing, but it does that quite often anyway. And Max laughs with $1 super chat. Thank you so much, Max. Max, you are the man. I'm just want to say that you've pointed me in directions that I never thought I would go. You're awesome. Thank you, Max. You are a true gem. I appreciate you. Really, I do. You're absolutely wonderful. Hey, Max. Hey, Max. Everyone is saying hi to Max. Oh, maybe not. Really wants to start out right away with this, doesn't she? Well, we just got to do it for you, you know, because there is nothing like being.
Welcome to the shit show.
Oh, every single day, sometimes twice.
A new
Flavor of buggery, cause everybody sucks, you see, and they're dumber than a bag of rocks. Monday, Tuesday, Wednesday, and 4 more days of increasingly stupid, ridiculous, ignorant, balderdash, poppycock, bollocks, and fuggery. Oh no, maybe not, never. You're not a quitter. There's no, so you can't quit because you know what'll happen. You'll go back and you'll watch it again because there's nothing like Tug and Megan. They're so much fun together. I love it. Speaking of fun together, you know what's happening tomorrow night? Gonna be over there with beautiful Mo in the Deep End over on her stream on Wednesday. It is a wonderful time, let me tell you, because we go over there on Wednesday. Right now we're doing the Coburger stuff. It is glorious. And we do that from Oh, I'm trying to remember. I think it's from 6 to 8 ish, somewhere around in there, which is really cool for us to do. It helps her out quite a bit because, she's got like family, that she has to take care of. And so it fits into her schedule. And I don't know if anybody else is streaming at that time, but it doesn't matter because we have a damn good time doing it. So you guys go check that out whenever you can. It's absolutely fun. And no, you never feel like a Tug. Never feel like you're quitting on Tug. Are you starting up trouble again over in Tug's chat? Heather, don't do that. Don't do that. We love Tug. We love Megan. They're awesome. Very little on that channel. I get in trouble too much. Well, that happens. Heather May, you got timed out for saying on a better channel that was taken out of context and why I left. Oh, yeah. Don't ever do that. Don't ever do that. Good evening. Hello, Kippy Tavernier. That's awesome. Getting pretty close to 10K. I just keep doing what I do. And if I get there, it's awesome. I'm just over ecstatic. I love it. And I'll have to do something really special for you guys if I hit that 10K, just like, I don't know, like a really long stream with, just having a blast, doing some like weird games, or who knows what'll happen whenever I do 10K. Oh, is that right? Tomorrow? Yeah, somebody was asking me about that, and I was like, I'm not sure if it's tomorrow or the next day. But see, we won't know anything about it until, Jeremy or which I don't even know if he'll be able to. I mean, he may say something about it if he's watching it, or if he's there. I mean, he would say something about it. And you sort of have to take that for what it is. You can only take so much notes. I think that, there'll be, I'm sure, something that comes out of it. Yeah. Tomorrow's the 6th. Yeah. That's going to be crazy. Well, the cool part about that part of the case, well, not so cool, but the interesting part of that case is going to be, do they allow the bankruptcy to move on? There's still going to be a lot of questions. Is the trustee going to get involved? How far is the trustee going to go? Are they going to start looking into a lot of the other shady money that might be floating around out there? I don't know. I mean, you won't know until we find out, and who knows? Who the F knows? But let me set this up for you really quick tonight. So this right here was an order denying leave to file the second amendment complaint. This is really short. Granted leave to file the third amendment complaint and denying the motion for preliminary injunction. And basically it states the same thing. Case arises from individuals' declining health, eventual death, dispute over the estate, probate proceedings are ongoing in state court. The plaintiffs assert claims in this court under RICO and on other grounds against multiple defendants. The plaintiffs apparently have not yet served process on any defendant. The plaintiffs have filed 2 motions, first for leave to file their second amendment complaint and second for a preliminary injunction directing the state court to stay its proceedings. The proffered second amended complaint is deficient in multiple respects. It rambles for more than 150 pages, hardly the short and plain statement required by Federal Rule Procedure 8. The second amendment complaint lumps defendants and claims together in an impenetrable mess. United States Court of Appeals railed against shotgun pleadings. Primary for reason is the need to make clear which allegations of a complaint apply to which defendants, which counts. The second amendment complaint names dozens of defendants. Among them are the state of Florida, state entities that plainly have 11th Amendment immunity. Regardless of relief sought, unless the immunity has been waived or validly abrogated by Congress under the 14th Amendment, we have often made it clear that relief sought by plaintiffs suing a state is irrelevant to the question whether the suit is barred by the 11th Amendment. Complaint paragraphs must be numbered. Most of the Second Amendment complaints paragraphs are numbered, but not all, and worse, the sequence does not run continuously. The numbering starts over at one more than once, so that Second Amendment complaint includes multiple paragraphs with the same number. That will not do. This order denies leave to file the plainly deficient Second Amendment complaint, but grants leave to try again. To file a Third Amendment complaint, any Third Amendment complaint must be labeled the Third Amendment complaint. It must be double-spaced throughout, except only in headings and footnotes, and all text included footnotes must be at least 14 point. The Third Amendment complaint should not include a 6-line single-space all caps footer as it does the Second Amendment complaint. All paragraphs must be numbered. So he's laying down the rules of what they're expecting. Another thing is saying, this is also, moreover, plaintiffs should note, well, there are limits on federal district court's ability to interfere with ongoing state proceedings in general or state probate proceedings in particular. Okay, so they can't put a stay on a state court issue. They're like, no, we're not going to do that. The plaintiff will suffer irreparable injury if the injunction does not issue. That threatened injury outweighs whatever damage the proposed injunction may cause the defendant, and that the injunction will not be adverse to public interest. With no viable complaint currently before the court, the plaintiffs have not established a likelihood of success on the merits, nor have they met any other requirements. So the order is a motion for leave to file the Second Amendment complaint, ECF number 8, is denied. The plaintiffs are granted leave to file a Third Amendment complaint. The deadline to do so is March 5th, 2025. The motion for preliminary injunction, ECF number 9, is denied. Okay, that's what set up this next filing, this one right here. And I highlighted a lot of this because there was so much to highlight and go through. And what I did is I skipped over a lot of the pleadings in it, and then it got towards the end, and I was like, we'll just let it go. Order dismissing the Third Amendment complaint. This case before the court on motions to dismiss the Third Amendment complaint is an impenetrable mess, yet again, as egregious a shotgun pleading as has ever hit the docket. This order dismisses the action on the basis and notes alternatively that the complaint fails to state a federal claim on which leave could be granted. All right, dismissal would be appropriate on that basis too. So 2 reasons why this should fail. Shotgun pleading, it talks about what is shotgun pleading, United States Court of Appeals, instructions district courts to strike or dismiss them even on the court's own motion. Resolving cases on the merits, which each side taking its best hold, has been my goal through the years. With sound case management, issues can almost be framed adequately, if not with precision, and cases can go forward. I have denied dozens of motions asserting complaints were shotgun pleadings, and I have granted leave to amend in dozens of other cases, so shotgun pleading deficiencies could be cured. And he has a few of them right there. Rare is the case in which plaintiff ardently refuses to clean up a shotgun pleading. This is the rare case. There might have never been a more egregious shotgun pleading than the original complaint and the 3 amended versions tendered in this case. The order granting leave to file the last of these, the Third Amendment complaint now before the court, warned the plaintiffs if the circuit shotgun pleading prohibition and provided citations to several circuit decisions setting out the governing standards. The order noted that a primary reason for the prohibition is needed to make clear which allegations of a complaint apply to which defendants and which counts. The order added any Third Amendment complaint must be short and plain and must conform with the law of the circuit on shotgun pleadings. Did I stay muted? Testing, testing, testing. Chat is down. What case is this? This is a case that was brought about by Michael Federigos in a in a probate case, I believe, some sort of guardian case or probate case. Now, the reason I bring this up is because what happens in one of these cases, the reason that that we can read these documents is in a guardian case or probate case, those documents are sealed where they're not available for the public to read. You can get the documents by writing to the clerk of the court. Okay. But you have to have a good reason for being able to pull up those pleadings. So whenever someone says that you're going after someone's case, and we'll go into this later, whenever you're going after someone's case and you're trying to go after victims, there's this case right here, there's no going after victims. That's not what this is about. This isn't going after victims. This is showing a really shitty written case and a judge calling someone out for writing a really shitty motion and saying, listen, we've told you multiple times, no shotgun pleadings. And the reason I bring this up is because Thursday, I'm going to go through the shotgun pleading that named me, Shizzywhiznut, in that shotgun pleading. And we're going to go through it. We're going to show you the comparison of what a good pleading should be and a shitty pleading looks like. And this is a prelude to that. Hey, how are you? Did you kick everyone out that were in here in the beginning? Like maybe not Elfie Cowboy and the others? No, I haven't kicked anybody out. No, nobody's been kicked out that I know of. Zach's here. Unless Zach kicked him out, I don't think anybody did. I stopped over on Expert Channel and Replay till I saw Shizzy started. Here we are for good and fun coverage. Well, thank you, Heather May. Now, see, she's there. Weston Bamba Rambles. No, it wasn't you. No, I no one's been kicked. Yeah. I don't think anybody's been kicked at all. I mean, YouTube may be doing something funky. I don't know, but I haven't booted anyone out of here at all. At least they shouldn't be booted out. I don't think anybody's done that. I can always take a look and see if we've got any issues on the chat side. Let me take a look and I can find that out really quick. Give me just a second. If we've got issues, I will know. Zach can also probably see if anybody's been kicked out at any point in time during this or timed out. But I don't think I've done that to anybody that I know of. So give me just a second and I will look and I can scroll up here. No, nobody's been kicked out. Dragon Lady Crafts was what I saw that got a membership. So I'm not seeing anybody that got kicked out of here at all. No, it looks all normal. Looks all normal. So if maybe it's something on their end. Lots of comments get deleted automatically by YouTube. The mods don't even see them. It's been very random lately. See, lots of comments get deleted automatically by YouTube. The mods don't even see them. It's been very random lately. Okay. It's a YouTube thing. It's been wanky all day. Okay. Wonky, wanky, wonky. Yeah. Close YouTube and reopen it. Yeah, it might be what's causing it. I had to go unblock people I hadn't blocked earlier. Oh, that's weird. That is so weird. Well, I hopefully figure it out. I really do. It's a YouTube thing, and there's nothing I can really do about that. The order noted that and there's a possibility, check your membership too. Check that you're still subscribed. Speaking of which, I think I can do this from here. Give me just a second. And we'll go back because, yeah, I had some really funky stuff happen earlier with YouTube, but it may just be a weird YouTube thing that's happening here. let me look and I'll see if there's something funky going on. No, let's see. We got, close that. I don't want to do that. And I am looking. I don't see. Give me. No. Where is? Yeah, I wouldn't have kicked maybe not out of here. No. Let me see real quick. Copy. And we'll put in here. I do not kick you. Here we go. And see. Well, if I could spell correctly, that would be great. I didn't kick maybe. There we go. See, here's what we'll do. So we will do this because I don't have to worry about it. There you go. And that's taken care of. Let's see. And they should be coming back in. Hey, Yamaha, just yell at me when it's story time. Oh, I will do that, brother. I was chatting, my chat blipped and then almost everyone was gone. Yeah, I don't know why. But we should be good now. Any third amended complaint must be short and plain and can conform with the law of the circuit on shotgun pleadings. In response to the order, the plaintiffs filed the third amended complaint. For convenience, this order often refers to it as the complaint. It's not short or plain and does not conform with the law of the circuit on shotgun pleadings. Quite the contrary, it is as bad as the prior versions or nearly so. It is an impenetrable mess. It spans 135 pages, includes 453 numbered paragraphs, not counting subparagraphs and unnumbered text. It cites documents and exhibits that were not included with the filing, and the defendants say were not served on them, which is just shady all the way. Now I have to see, maybe not. Yeah, you do. Now, it also goes on to say that the plaintiffs say they provided voluminous, tangible, and factual detailed support for their claims at an unspecified location within 1,139 pages of material filed previously. Now, that's the total amount of pages. Some of the materials could perhaps be considered a motion to dismiss. Much of it could not. And more importantly, at this point, the plaintiffs cannot cure the complaint's shotgun pleading violation by suggesting the court and the defendants plow through voluminous, extraneous material in search of facts not properly included in the complaint itself. The mass of unorganized material not tied to any specific defendant or court compounds, it does not cure the shotgun pleading problem. Now, what they're saying, what the judge is saying right here is there's, if you would have listened whenever I told you earlier, you dumbasses, that you can't file a shotgun plea, if you would have just listened, then we wouldn't have this problem. This problem would not be happening. We would be absolutely fine. We'd be good to go. But you didn't fix the problem. You just amplified it and refiled the same garbage that I explicitly told you not to. And if people want to say it's some sort of cabal or some crap like that, no, it's a shitty filing. If you don't listen to what the judge is saying, he's going to smack you down for this. A reader of the complaint, with or without separate materials, is left to guess which allegations relate to which counts. Successive counts incorporate prior allegations with little rhyme or reason. And a reader is sometimes left to guess which plaintiffs assert claims against which defendants in which counts. The complaint makes little effort to mask this, often referring to plaintiffs or defendants, and thus leaving the reader to guess whether an allegation relates to one plaintiff or more, or to one defendant or more. If more than one, the complaint leaves the reader to guess which ones. This is a do your best to figure it the fuck out approach. It's precisely the kind of thing shotgun pleading principle prohibits. with broad conclusions but few flat facts. The complaint alleges that 23 defendants engaged in RICO enterprise whose purpose was to fraudulently deplete a now deceased individual's assets and the estate that is being administered in a Florida state court. Some of the allegedly fraudulent actions, though not all, were approved by the state court. And if you hadn't seen what they're talking about, if you and I could go back and read the actual part of the complaint that they had, is basically they're complaining things that the state court has already said, no, this is absolutely fine. The state court's approval matters, as the order granting leave to file this version of the complaint warns the plaintiffs. The plaintiffs should note well, there are limits on federal district court's ability to interfere with ongoing state court proceedings in general or with state court probate proceedings in particular. And this is exactly what he quoted to them in his order that denied them filing that second complaint, because he saw what the second complaint looked like and he said, oh, hell no. You can file a third complaint and it better be cleaned up. And they didn't listen. He's not going over anything of what the substance of is going on in their first case, just as I'm not talking about anything that's going on in as far as substance goes in their first case, except as an example of what's going on in this particular case. Cases brought by state court losers complain of injuries caused by state court judgments rendered before the district court proceedings commenced and inviting district court review and rejection of those judgments. ECF 12 at 3-4 complaints vague allegations and haphazard incorporations by reference make it impossible to sort out which parts of the claims are barred by these principles. Many of the complaints' conclusions, including apparently a veiled suggestion of murder, are unsupported by factual allegations. And we just read one earlier this afternoon that was the same damn thing. There was nothing in here that was supported by factual allegations, plausible or otherwise. And it's just like, did you not pay attention to what the judge had to say? Jack Miles, look at you. You know you love it. Welcome, brother. Welcome, and thank you for the 4 months.
Welcome to the shit show.
Yes. Every single day, a new flavor of thuggery, 'cause everybody sucks, you see, and they're dumber than a bag of rocks. Monday, Tuesday, Wednesday, and 4 more days of increasingly stupid, ridiculous, ignorant, balderdash, poppycock, bollocks, and fuggery. Oh, yes. Thank you so much for being here for 4 months. Now, fraud must be alleged with particularity. But here the allegations of fraud would not pass muster even under the relaxed standards application to other subjects. The plaintiffs seem to have sued almost everybody who dealt with a decedent, his health care or his estate. Even for the 3 primary defendants, the complaint's factual allegations are not sufficient to state a claim on which relief can be granted. And see, that becomes really damn important. A classic shotgun pleading is a complaint that contains multiple counts where each count adopts the allegations of all preceding counts, causing each successive count to carry all that came before, and the last count to be a combination of the entire complaint. And if you don't understand what that means, and I can make it really simple, if you look down, you'll see at the top of some of these complaints, you'll see something that incorporates everything paragraphs 1 through 13 as to be incorporated into this. Then I'm just using that as an example. And then you'll go down a little ways further. And I noticed this, and I had to actually ask an attorney about it. I was like, so why does this next one say as paragraphs 1 through 13 as the same way? What they told me is because this is a different count. So, for example, you got count 1 is against one plaintiff, count 2 is against another, or defendant is against one defendant, count 2 is against a different defendant, and their crimes might be slightly different. So you've got count 1 up here, and it says 1 through 13, and 1 through 13 happens to be a basic that covers everybody. And then it'll go down and it'll say 1 through 13 are as incorporated. So this way they're not grabbing 1 through 47 to file those in there. And it's if you've ever read a complaint, this is the way that the complaints are made. And I can always pull one of those up just to give you an example of the way that it looks and why it can look really funky and weird. But that's why they're written like that. Another type of shotgun pleading is one that asserts multiple claims against multiple defendants without specifying which of the defendants are responsible for which acts or omissions, or which of the defendants the claim is brought against. I mean, you can't deny that right there. Further shotgun pleadings include complaints that are replete with conclusory, vague, and immaterial facts not obviously connected to any particular cause of action. The complaint violates all these principles. 10 of the 12 counts incorporate all preceding paragraphs, including those in prior counts, and this makes it impossible to know what the fuck are you talking about, is what he's saying. Generally making it impossible for those allegations to know which defendant allegedly did what. The complaint is replete with all of your bullshit. This is especially true considering the plaintiff's reliance on a mass of unorganized additional materials. Before a case is dismissed with prejudice on shotgun pleading grounds, a plaintiff must be given fair warning and an opportunity to amend. That was done here. The order denying leave to file the second amended complaint explained the shotgun pleading problem and granted leave to file a third amended complaint, explicitly warning that any third amended complaint should not be a shotgun pleading. And we just read that. It's almost like they didn't listen. It's weird how that happens. If ever there was a case that should be dismissed with prejudice on shotgun pleading grounds, this is it. This order should end at this point. But even if not dismissed as a shotgun pleading, the complaint would be subject to dismissal on alternative grounds. The remainder of this order addresses some of the complaint's other deficiencies and, in addition, attempts to preserve some of the perspective that has been gleaned through many hours of trying to sort all this bullshit out. To survive a motion to dismiss for failure to state a claim on which relief can be granted, a plaintiff must plead factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. For purposes of a motion to dismiss, the complainant's factual allegations, though not its legal conclusions, must be accepted as true. A motion to dismiss is not a vehicle by which the truth of a plaintiff's factual allegations should be judged. Instead, it remains true after Twombly and Iqbal, as before, that federal courts and litigants must rely on summary judgment and control of discovery to weed out unmeritorious claims sooner rather than later. A complaint must stand or fall on its own factual allegations, with this exception. Proper attachments and a narrow category of other materials may properly be considered. Here, in addition to its own voluminous and sometimes virtually incomprehensible allegations, the complaint refers to other materials not attached to or properly cited with specificity in the complaint that the plaintiffs say count towards the required factual allegations. The defendants say the plaintiffs have not served or otherwise provided them with copies of the materials. In addition, the plaintiffs' responses to the motions to dismiss refer without pin sites to an earlier filing. ECF number 8-1 consists of 1,139 pages of often irrelevant materials. The plaintiff asserts these materials to count towards the required factual allegations. Some of the defendants have also filed extraneous materials. Some of the materials could perhaps be considered on the motions to dismiss. Some plainly could not. This order includes citations where feasible in an effort to make clear where the information came from, and in an attempt to allow a reader to make sense of the complaint. Some information is included here as background, even though not alleged in the complaint or included in properly considered additional materials. That background information has not affected the decision. In support of the reliance on extraneous materials included in ECF number 8-1, plaintiffs say this in their response to a motion to dismiss. Now, this is from their filing. On February 11, 2025, plaintiff filed a motion to amend Doc 8, which attached Exhibits 8-1, providing voluminous, tangible, and factual detailed support for allegations. So what they're saying here is, if you look in Doc 8-1, Doc 8, providing voluminous, tangible, and factual detailed support for the allegations, the court granted leave to amend on February 12th, and pursuant to this order, plaintiff filed the third amended complaint on March 2nd, which incorporated reference to previously filed exhibits from Doc 8-1 under Federal Rule of Civil Procedure. A copy of a written instrument is an exhibit to a pleading as part of the pleading for all purposes, and the courts have constantly held that documents incorporate by reference to this matter become part of the operative complaint. So what they're filing, I'm not allowed to read this. Yep, absolutely. Go for it. I would love to see them come after me for that one. They can say all they want to, and we'll get into that later. In support for the reliance on the extraneous materials. Now you have to understand all of this right here. This particular one, and I'm going to highlight it so you guys can sort of see what I'm talking about here. That, and why did it do that? There we go. What they said was their reason for not resubmitting a comprehensive exhibit sheet was they were using the Docs 8-1, their voluminous bullshit of exhibits, and said, well, it should be good enough. Instead of going back and sorting it out and making it plain, they said, you go look at 8-1 and you figure it out. This statement is incorrect. They're filing right here where they try to quote Civil Procedure 10-C as a copy of a written instrument as an exhibit to a pleading as part of a pleading for all purposes. That response right there is incorrect or misleading in several respects. First, the February 12th order explicitly denied their motion for leave to file the second amended complaint. So that complaint was never filed. Denying number 8, the order most assuredly did not suggest the materials attached to the second amended complaint, that is ECF 8-1, were properly before the court or could properly be incorporated by reference to a third amended complaint. So just because you threw the shit in there and the judge said, nope, we're not taking anything from 8, you are going to have to refile that. That means refile it in its entirety. He denied 8. He said, no, 8 doesn't matter. Where are you? I'm in my bedroom being sexy as always. What are you doing? Second, the third amended complaint does not cite ECF number 8-1 or provide any clear reference to any specific part of ECF 8-1, and the Third Amendment complaint sometimes has footnotes referring to materials, but even in those instances, it doesn't provide a unique exhibit numbers or pin sites or any other means to locate the reference material. An example of the confusion, a footnote in the complaint refers to Exhibit A, but ECF number 8-1 has 8A exhibits marked A1 through A8, and the footnotes does not specify which of any of it refers to. We have no idea where this shit belongs. And apparently, if not, okay, other materials referred to in the complaint are not included in it and apparently have not been served or on or otherwise made available. So what the judge is saying here is you're referencing material that you haven't served on anybody. You're referencing exhibits that haven't been brought forward. You're referencing garbage that doesn't exist. The plaintiffs are wrong when they suggest the court and the defendants can be required to go through 1,139 pages of often irrelevant materials in search of voluminous, tangible, and factual detailed support for their claims. See, if you're a plaintiff, you want to be able to point to a plaintiff or a defendant, you're filing a motion, any one of those. You want to be able to look at it, and the judge wants counsel on the other side, the people on the other side, to be able to go, okay, just like he's doing right here. And I'll point it out. I'll highlight it so you understand. ECF number 9 at 17. What he's saying here is ECF, which is the electronically filed document number 49 at 17, which either could mean at count 17 or paragraph 17. The plaintiff's reliance on invoices of defendant Big Ben Hospice ECF 49-1. The plaintiff's separate filing of these invoices in response to Big Ben's hospice motions to dismiss. So this right here is out of ECF 49-1. The materials the plaintiffs rely on are not attached to the Third Amendment complaint or otherwise accessible or not part of the pleading or not properly considered as motions to dismiss. But shit. This wouldn't make any difference anyway. A substantial portion of the materials are completely irrelevant. Like they're forwarding to irrelevant material. For example, an individual apparently sued the defendant Kessler nearly 20 years ago for allegedly defamation, having nothing to do with the case at bar or the case that they're talking about. Numerous filings from that case are included in ECF 8-1 with no explanation. And this right here is going to be very important. Think about this. All right. Every time they bring up, now you've got to be listening really carefully because I want you people to understand this. Every time that they bring up bullshit about Randy, okay? And they keep saying, oh, Randy did this and Randy did that, and he did do this and he did do that, and he's in a lawsuit. Every time they bring up Jeremy Hales and say, Jeremy Hales has multiple lawsuits elsewhere and he's doing this. Every time they file one of these notices to a court bitching about it, they're burying themselves even further. Because just like the judge says here, an individually apparently sued Howard Kessler 20 years ago for alleged defamation having nothing to do with this case. We're talking about this case. Any issues that Randy could have or did have with the bar in Arkansas, Alabama, whatever, bear no relevance whatsoever to any of Lynette's cases, bears no relevance whatsoever to any of Federigos's cases. It bears no relevance to any of the cases that he's in. None. Zero. Has nothing to do with it. Why? Any reason that they want to bring up anything about Jeremy having sued people before bears no relevance unless it's vexatious litigation, unless they can prove that he is doing this and then dropping cases, bringing a case, dropping a case, bringing a case, dropping a case, bringing a case, dropping a case, and does it to do nothing but to harass people. And he hasn't done that. He's brought a case. He's following the case through. Make sense? Hopefully that does. From that case are included ECF number 8, no explanation. The case apparently was settled with no finding of liability in this lawsuit. Similarly, random medical records from other patients are included in 8-1. Perhaps to show that Dr. Kessler served on a state court medical examining committee, which is undisputed. Also included in ECF 8-1 are minutes of numerous meetings of the board of directors of Friends of Wakulla Springs State Park. Again, totally irrelevant, but included in the exhibit with no explanation. If there's anything relevant in ECF 8-1, the plaintiff's message to the court and defendants is apparently, go find the shit yourself. This compounds the shotgun pleading violation. Okay. Now we're getting down into the facts. Now he's saying, accepting is true, the facts alleged in a well-pleaded complaint is usually an easy first step towards analyzing a motion to dismiss. Oh, no, not here, young children. Sorting out the facts from a 135-page pleading full of bluster and conclusions is challenging. This order is a best effort, nothing more. The presentation as organized as follows. A, beginning 17. B, April 2018. C, July 2019. D, September 2019. E, October 2019. F, October 2019, August 2022, healthcare decisions and expenses. And this is where it gets even more long and drawn out. H, state probate. State guardianship, state court guardianship proceedings, Lambau's death, and state court proceedings, and K, other individuals. Okay. Sorry. I was getting over anxious here. In the beginning, the facts in this section are not included in the complaint and thus are not part of the analysis of motions to dismiss. Okay? So pay really close attention because they're not included in the complaint and thus are not part of the analysis of motion to dismiss. A reader may find it useful background when attempting to sort out the factual allegations about later events, the allegations that matters. These defendants included in this background are their motions. Some of the information is also available from state court records that could be judiciously noticed after appropriate notice and opportunity to be heard for the limited purpose of showing the course of these proceedings, though not the underlying facts. Florida probate and guardianship dockets are not available online. Again, Florida probate and guardianship dockets are not available online. So finding and verifying those records would require further steps. Okay? Do you understand now why we don't talk about guardianship cases? Why whenever you hear a moron saying, well, it sucks that they don't understand the facts of the case. The judge says it right here. It's almost like they didn't read anything that the judge told them to do or not do. Interesting enough, before going further, a word is in order about the complainant's identification of the defendants, because we can't figure out what they mean. The placement of firm and stray space after law are apparently just typographical errors, And the style apparently was meant to include Miss Sketchley, her law firm, and the Sketchley method, whatever that means. But the Sketchley method is not included as a defendant in the text of the complaint. The inability to sort out who is actually being sued is yet another indication that this is a shotgun pleading. Background facts, unverified, not alleged in the Third Amendment complaint include the following. Victor and Geraldine consulted Miss Sketchley about alleged abuse of Victor's wife, Lorraine, by Victor's other daughters, Denisha and Vicky. As attorney for Victor, Sketchley filed a state court in Wakulla County a petition to appoint an emergency temporary guardian for Lorraine. The court appointed Victor and another individual, Diane, as guardians for Lorraine. After an evidentiary hearing, the court issued an injunction against Denisha and Vicky. 3 days later, Denisha and Vicky filed in state court in Leon County purportedly on behalf of Lorraine, a petition for domestic violence injunction against Victor. The court entered an injunction. As attorney for Victor, Sketchley filed an emergency motion to vacate the injunction. The court immediately granted the motion and vacated the injunction. And simply said there was something filed, there was an injunction placed, and they vacated the injunction. That's all that they're basically saying. Now, Lorraine died in a hospital in 2017. Denisha and Vicky alleged that the county sheriff's office that Lorraine died under suspicious circumstances, and that the sheriff's office declined to investigate. Okay? This is the facts according to what the judge can parse out. Not mine. Don't know anything about it. April 2018, there was an estate planning. In April of 2018, he obtained estate planning services from Sketchley. They planned out the documents. Sketchley advised Victor to create a revocable trust, irrevocable upon his death. Victor was the trust settler trustee. His daughter, Geraldine, was the successor trustee. Denisha and Vicky were not included. Allegedly based on Sketchley's advice, Victor transferred his home to his trust. He also executed a will naming Geraldine as the representative. Finally, he executed advance directives giving Geraldine durable power of attorney. I don't know what that means, but basically making her power of attorney and making her his healthcare surrogate, which wouldn't be uncommon. And let me put it this way. If you've got a member of your family that you trust and maybe also is in a healthcare environment, like my brother-in-law, because he's in the healthcare field, has more experience talking medical things. Before my wife's father passed, there was talk and consideration of this. My wife, because she's an attorney, was looking at, hey, I want you to be trustee. You make medical decisions, son. Daughter make this, son make this. And that's how they work things out. But this person he trusted, plus they were in the healthcare, so hey, let's have her do both. He also executed a will naming Geraldine as the personal representative, which means that she, whenever he passes, that she becomes sort of can hand out the money as it's supposed to go, pay all bills with that. Finally, he executes advance directives, giving Geraldine the durable power of attorney, making her his healthcare surrogate, and it was filed in the state court in Wakulla County. Now, Victor started declining in 2019. Geraldine moved in with Victor to help, which wouldn't be uncommon for somebody that you trust that would come in, move in, help take care of you. If you're starting to decline, they may cook for you, clean for you, help you in and out of the bath, in and out of the shower, whatever it might be. They make sure that you get all your medication on time, take you to doctor's appointments, almost like a live-in healthcare worker. Victor and Geraldine signed an agreement providing that in exchange for her caring for him, he would not charge her rent, which means she wouldn't have to pay rent You can stay here for free. That's part of the payment. He would also be responsible for all other items needed by her, which would be pretty easy to say, hey, you know, she's staying here. She's taking care of me. If she needs groceries that will feed me, then sweet. Geraldine became concerned about his ability to make proper decisions because it's a possibility that he might have been declining. I don't know the situation. According to the complaint, she witnessed Victor's house cleaner attempting to steal, and the complaint doesn't make clear why this mattered other than Victor did not want to fire the house cleaner and disagreed with Geraldine on this. The complaint, this is the complaint that was filed by at this point, I'm fairly well lost. So I'm chewing your toenails. Well, if you jump in here, we got a story we can read anytime you want to. Victor didn't want to fire the house cleaner. She said no, and it alleges suspicions arose when the house cleaner attended Victor's funeral. In 19, the suggestion of acquaintance contacted two of the defendants, Kessler and his wife, Ann Van Meter, and the mass exhibits the plaintiff filed. There were text messages in which Geraldine asked Dr. Kessler to call another doctor who had no appointments. After a call from Kessler, Katz agreed to see Victor. The text messages seemed to indicate that Dr. Kessler and Victor were friends. Kessler offered to bring ice cream to Victor and Geraldine, saying he would love that. The complaint alleges he was unknown to Geraldine, that Dr. Kessler and Miss Van Meter sketchily had a previous working relationship, including in guardianship cases. So these people worked together before. Well, why wouldn't you work with people that you already know and trust? Makes sense to me. In 19, Katz diagnosed Victor with dementia. Katz recommended Victor stay in his home with in-home services. Katz recommended that Geraldine take over managing his money. It says Dr. Katz practiced under the defendant FSU Senior Health. In 19, Victor told Sketchley that he and Geraldine were having disagreements over the resistance to firing. And Ms. Sketchley recommended Victor temporarily relocate to Tapestry Memory Care, a facility that cares for patients with dementia. The complaint says that Dr. Kessler, Van Meter, Sketchley misled Victor to believe the move was temporary and simultaneously Geraldine to believe the move was necessary to protect Victor from the house cleaner's alleged theft. The Sketchley defendants assert in their motion. So basically what they're going through here is saying all of this buildup was basically you've got somebody that's on a decline, and whenever they're starting to decline, they're making moves to protect him, his assets, whatever it is that they need to do to make sure that he's put somewhere and somewhere safe. Especially with dementia, that can be really bad. If you haven't ever dealt with someone with dementia, they can do things like empty an entire, thing of hot coals into the forest, thinking that the coals were cold, and not even think twice about it and set an entire forest on fire. I've seen these kinds of things happen. Okay. Sketchley asserts he was distressed, but had capacity. She immediately contacted Adult Protective Services, arranged for Victor to reside at a local assisted living facility, which he admitted himself into. Because these allegations are made only in a motion to dismiss, not in the complaint, they cannot be considered on the motion to dismiss. The allegations are recounted here simply as a description of the motion to dismiss. And dementia is hard to handle. It also alleges the following. Through 19, Sketchley Kessler committed various types of fraud. No specific dates are given, which is a big no-no. The complaint does not allege with specificity who said what to whom, when, where, what, how, or why the recipient of the statement did, based on the statement that the recipient would not otherwise have done without authority. Says that he signed a couple of checks totaling of $7,000 without notifying Geraldine. The complaint provides no further information about the checks and does not include, for example, the possibility they were payment for the assisted living facility's legitimate charges. It says that when Ms. Sketchley completed paperwork for the facility, she falsely stated Victor had no advance directives. See, saying that she falsely stated that he did, but they're not showing any proof of what they're saying. They're just saying, well, she falsely stated this. That's conclusory, and you can't submit that. In 2019, he signed a petition for voluntary guardianship over his property. He requested appointment. Katz attested to it. He revoked the durable power of attorney named Geraldine and signed an amendment in his trust appointing Miss Van Meter as trustee. The complaint alleges that to persuade Victor to sign these documents, sketchily misrepresented Mr. Helfand and Miss Van Meter's qualifications. Meter replaced Helfand as court-appointed guardian. Guardianship was over the property, not his person. Alleges sketchily made these changes without notifying Geraldine, Denisha, Vicky. Geraldine did not become aware of the estate until 2020 when she was notified that that durable power of attorney naming her had been revoked. From 19 to 22, took Victor into his medical appointments, complains that Dr. Kessler falsely claimed to be Victor's family member, son, lifetime friend, power of attorney holder, healthcare surrogate, all this kind of crap. The massive materials filed by the plaintiffs included in healthcare surrogate form naming Dr. Kessler by its terms was effective only upon Victor's inability to make his own decisions. Geraldine often thanked him, sent heart emojis, and she would miss him when he went on a trip. It says that Dr. Kessler's unspecified, they haven't specified which false statements he made, caused Dr. Katz to change his recommendation that he reside at home. More complaints, more bullshit. Kessler tried to decline the referral fee, but the unidentified facility insisted on it, and Kessler declared it on his income taxes. So, he's saying, I don't need anything. I would have done this. The cost of Victor's stays in various facilities totaled approximately $319,000 because of double and triple billing to Victor's estate. This is what they claimed. Ms. Van Meter or Victor also issued checks for reimbursement to Dr. Kessler that the complaint alleges were fraudulent. Some of the payments were approved by the state court after a hearing. So it was already done. Sketchily reported Geraldine to the police for making unauthorized decisions about Victor's property. So it sounds like the daughter that was in home, the live it in with him. Good afternoon, Emma. Good afternoon. We'll get to you here. Contacted law enforcement, adult protective services, medical professionals in the court about Geraldine. The complaint alleges that Dr. Kessler fraudulently took $54,000 from Victor's accounts. The complaint includes images of checks totaling $4,495 with the subject lines marked reimbursement, rent, or expenses, Victor. The complaint does not specify what was fraudulent about these checks. In addition, the complaint says Dr. Kessler fraudulently obtained a court order for reimbursement for serving as Victor's healthcare service, although he was not actually his healthcare surrogate. These expenses were paid pursuant to a court order that was entered after a hearing. Next, the complaint, Kessler sought to reimburse for expenses that were already paid. Also further alleges from that sketchily Van Meter mother campaign donors of Kessler and the defendant William Johnson took substantial funds without authority and without seeking court approval. Yes, good afternoon there, doll. So good to see you, Emma. I hope you're having a wonderful day today. It makes me so happy to see you here. Hey, how's it going? Don't worry about late arrivals, early arrivals. You all are welcome into the house of nuts. At some point, they hired a private investigator to conduct surveillance on Victor's home, paying for it from his income without court approval. They arranged for a dumpster service to take substantial amounts of Victor's property, even though it was in good condition. The complaint alleges the possibility someone was paid for the property. In her deposition, Ms. Van Meter said that under the terms of the voluntary guardianship over property, she was able to pay Victor's living expenses without court approval, but otherwise needed approval to dispose of property. She had court approval to sell his vehicles, donate some household items, and give his rare plant collection to a nursery. which is good. That's what you want. Coming over from Tug's. Welcome, Goosebump. Welcome, welcome, welcome. It is a wonderful thing to have you here. Oh, don't you worry about it, Marianne. Getting you here is all that matters. Come on over anytime. We're always happy to have you here. Other complaints related to property. And of course, they've got more complaints. They allege that all these individuals instantly, knowingly took tainted money and constituted a racketeering influence. A RICO enterprise is facially implausible, and nothing in the complaint or elsewhere in the record supports this allegation. Very clear. His home was sold for cash. They ran the numbers and they believed that it was undervalued by $100,000. Now, if the house had work that needed to be done on it, I could see that happening. The funds were put into a trust and used to make unauthorized payments for housing to various people. Mr. Hutchinson is named as a defendant allegedly to be a member of the enterprise, apparently based on nothing more than having performed audit. So, this is this. Harbor Point Realty, Shasman, Hayward Title Group, Southern Oak, Mr. Hutchinson is named as a defendant and allegedly a member of this enterprise, apparently based on nothing more than having performed ordinary professional duties in connection with the sale of the home for the first three and having bought the home at arm's length for the last two. No, this particular one is not about the suit against Lips and Doritos. This right here is what Doritos filed in a federal court, and the judge gave him the slapdown. This is the 50-page ruling that they are losing their ever-loving mind over. You can't read this. I am reading what's been filed in the court by a federal judge. It's a public document. Anybody with a Pacer account can pull this information up. State court guardianship proceedings. Oh, we're only on H. Jesus. It goes into basically that they filed emergency motions, and state court ultimately referred the entire case to the Florida bar for review. But the court did not single out a specific attorney. Instead, the court said it fully trusted the bar to inquire into any attorney conduct, whether it be good or bad. They're going to look at it and they're going to see what exactly is going on. Ikea Doritos. Victor's death. It alleges healthcare fraud resulted in death. The conclusion is unsupported by plausible allegations of fact. Nothing in the complaint suggests the defendant healthcare providers committed fraud or failed to provide appropriate medical services conforming to the relevant standard of care. Even more clearly, now, and listen to what I'm saying. I'm not saying that they did or did not. What the judge is saying is the conclusion is unsupported by plausible allegations of fact, because nothing in this bullshit complaint that they filed suggests the defendant healthcare providers committed fraud or failed to provide appropriate medical services conforming to the relevant standards of care. Even more clearly, nothing suggests that they contributed to his death. Similarly, nothing in the complaint suggests the real estate defendants committed fraud or failed to provide appropriate services conforming to the relevant professional standards of care. Even more clearly, nothing suggests they contributed to Victor's death. It is the complaint's reckless allegations, not any alleged misconduct of these defendants, that departs from the relevant professional standards. Let me read that again. It is the complaint's reckless allegations, not any alleged misconduct of these defendants, that departs from the relevant professional standards. Dr. Kessler reported to Katz. They told Big Ben Hospice they were his healthcare surrogates, held his power of attorney. The complaint alleges they made end-of-life decisions that led to Victor's death and did this strategically to prioritize financial gain over patient care, deliberately refusing life-prolonging medical interventions. It alleges Kessler Van Meter wanted to secure a quick death so as not to deplete funds they intended to steal, without citing any basis for the allegation. The complaint says the defendant's conduct led to his suffering at his death, grasping for oxygen and screaming in pain. The daughters were not with Victor when he died, so they could not be the source of this information. Ms. Sketchley filed notice of death in the Leon County case 2 months after Victor's death. The daughters say the delay prevented them from attending the funeral because they did not know about the death. So it can only be one or the other. Either somebody, which would have been the only people there, would have been the daughters because they provided no proof of anybody else saying anything, but the daughters weren't even there. It's like, we've got this verifiable proof. Well, what's the verifiable proof? Who was there? Do you have a witness that wants to come forward that they were there when this happened? It's like this fantasy that somebody lives in. Now, during the probate proceedings, Denisha Geraldine initiated probate proceedings and were appointed personal representatives. In those proceedings, Johnson, Sketchley, Van Meter, Dr. Kessler requested guardianship fees, which is not abnormal. They explained she had not sought fees. Ms. Sketchley explained that she had not sought fees while Victor was alive because under Florida law, she was unable to wait and file the petition after he died. She said she was concerned he would run out of liquid assets if he lived long enough. The complaint alleges Mr. Johnson, Sketchley, Van Meter, Kessler failed to notify the court that funds, not clear which funds, had already been collected. It also alleges these defendants filed fraudulent billing documents, which is shitty if someone's doing that. Absolutely, that's crappy. But here's what the problem lies. There were hearings in state court on the amounts owed to various professionals. Parts, not all of the state court record, are included in the record at the case bar. Kessler sought fees as healthcare surrogate. The state objected, and Kessler was just a friend. The state argued that healthcare surrogates not appointed by the court are not entitled to guardianship fees as a matter of law. The statutes do not speak to them. The state also noted the potential conflict of him being married to Miss Van Meter. At some point, Kessler abandoned his request for surrogate fees. Yeah, usually you're just like, I mean, I'm seeking fees, but I could care less. I mean, he was my friend, but I mean, I was also performing a service, but hey, whatever it might be, whatever you want. They attempted to focus the issues, asking to clarify why going to lunch was a healthcare surrogate job. A well-respected retired judge testified that Miss Sketchley's fee was fairly conservative. Probate proceedings is apparently ongoing. The complaint alleges no facts plausibly suggesting the state court is not fully capable of doing its job and administering the state. Perhaps in an attempt to show a pattern, the complaint alleges Miss Van Meter has done the same kind of thing to others. The complaint identifies one alleged victim by name, but provides little factual support for the assertion the person was mistreated. This is the judge's order, 50-page document. Don't worry, we have a letter coming up really soon. Probably within the next, I would say, probably next 20 minutes, we'll have another letter coming up. And we are going over a few of these things because they really are irrelevant. The complaint alleges no basis to believe this is relevant to the case at bar. And you're going to see a lot of that throughout this entire thing. The case style lists 23 defendants. There are very few specific, non-conclusatory allegations of facts suggesting they engaged in wrongdoing. For others, there are few factual allegations at all, none plausibly suggesting wrongdoing. The linchpin of the complaint is that each defendant was a member of the enterprise and assisted in the facilitation, implementation of the sham probate enterprise to enrich themselves and for the express purposes of harming plaintiffs and acting contrary to wishes of the victim. And I'm not going to go through the list of all of their horrible things that they did because it's irrelevant to this. This is a flow sheet. The third amended complaint has 12 counts. It's not clear which counts are asserted against which defendants. Most counts incorporate every preceding paragraph, including those in preceding counts. Other counts incorporate specific paragraphs, not clear at which time the plaintiffs assert which claims. So we don't know what believes to what. And the examples of this is, and this is why I wanted to get to this. Violation of RICO is count 1. Alleges predicated acts of all these horrible things. Florida RICO, not clear who this is against. It specifically lists Kessler, Van Meter, Sketchley, but the count incorporates all federal RICO allegations. So what they did is they incorporated everything up here. Civil conspiracy. It did the same thing. It included everybody up here. And then the same thing with this. It included everybody above this. And the same thing with this. It included all these people into something. So it was unclear who did what at what time, during where, and you're saying all of these people are part of the RICO conspiracy without proving any bit of that. And they go all the way down through every single count, making it very confusing for anybody to read. Letter time? Oh, yeah, that's right. You better limber up, stretch your throat and gargle. It doesn't sound wrong. It sounds so good. And the ladies love it when you gargle. Oh, yes, they do. Under Rooker-Feldman doctrine, district courts cannot hear cases brought by state court losers complaining of injuries caused by state court judgments rendered before district court proceedings. Basically, he's saying, yeah, we can't make decisions on this. On certain parts of this, we can't even make it. Parts of the plaintiff's claims are barred by it. The guardianship and the probate court's orders overseeing the administration of the proceedings count as judgments. Holding that a complaint based on a probate court's orders was barred by Rooker-Feldman. But this complainant's opacity makes it difficult to sort out what the state court did and did not approve and whether any entire account could be dismissed on the basis. The court approved some expenditures the plaintiffs now challenged, but other transactions, payment of ordinary living and expenses or sale of the residence, for example, did not require court approval. If the complaint was not going to be dismissed as a shotgun pleading, it would be appropriate to take steps to identify and excise any claim over which, based on Rooker-Feldman, the court lacks jurisdiction. Does that make sense? Okay. I'll try to make sense out of this. All the shit that we just read, all that previous crap about what did who and did where. What he's saying is, and he used those as examples as far as what he could parse out of what was going on in this situation. And what he's saying is because you couldn't sort out the difference between what the lower court can handle, this other court can handle, as compared to what this court should handle, we couldn't parse out the difference between the two of those. So your pleading sucked really bad. It sucked so bad that we couldn't figure out, is this a state court issue? that should be handled there in Wallika, or whatever the name of the county is. Wallika County, they can handle the certain parts of this, but you never pointed out in your pleadings what parts of this could be handled by that county. And in doing so, you wrote a bunch of gobbledygook that we're not going to sit here and waste judicial sources trying to parse out what goes where. That's your job, attorney, whenever you're filing these kinds of pleadings, that you need to sort out what bucket goes where, how this is handled by each individual person. And he didn't give them one. He didn't give them two. He gave them 3 tries at getting it right, and they still couldn't get it right. It also implicates other jurisdictional principles. Discussing the probate exception to a federal jurisdiction, the Supreme Court has said federal courts of equity have jurisdiction to entertain suits in favor of creditors, legatees, and heirs, and other claimants against decedent's estate to establish their claims, so long as the federal court does not interfere with the probate proceedings or assume general jurisdiction of the probate or control of the property in the custody of the state court. Is this a state court issue or a sick joke? It is a sick joke. That's the problem. The judge could never figure out what any of this was. I mean, he could parse out some of it, but he couldn't tie anybody to any one thing of doing any particular thing at any particular time. Well, this case was in federal. There has been an appeal filed on this, but they have until, I think it's like September 9th to actually make that appeal go through. There's certain filings and crap like that. They've already started the process. They filed notice to file appeal, which, then you have to get like court transcripts. You have to get all of the documents together. So everything that they file for this appeal has to be brought in. They send it to and I don't know how it works in other states, but in the state of Georgia, the way that it works is the clerk assembles everything that you need for that appeal. And it's basically the entire case, any transcripts, anything like that. And then it goes to the Court of Appeals. Whenever it gets to the Court of Appeals will look at it and they will decide whether they want to take the case or not. Sort of like the Supreme Court, or what is that, right? Yeah, the Supreme Court, the United States of America. They don't take every single case that comes to them. They vet them. There's high scrutiny on those cases. And if they read this judge's order, most likely your appeal is going to fail before it even gets there. And there's a possibility if they file it really shitty, like they do all their other crap, that the appeal court will just say, oh, hell no. And if it looks like they're a frivolous or a vexatious litigant or a frivolous litigant, they will put a hold on anything that gets filed until it is absolutely reviewed. An appeal court doesn't have to take the appeal, and they will only take appeals that meet certain standards. I mean, you can file it, but those usually happen pretty quick. Once the clerk assembles everything, they send it off to the appeal court. The appeal court looks at it and they decide whether they're going to take it or not. If it fails, just even on the legal merits, they won't even hear it. They'll just kick it back and say denied. That makes sense. And I could be wrong because it could be different in other states. I just know that's generally how it works. Like I said, not an attorney. I've just had to send stuff to appeal courts before. Majority of plaintiffs' claims apparently would interfere with the ongoing probate proceeding. Some of those would not. For example, the defamation claims probably raise no issue with the probate proceeding at the same opacity that prevents a reliable Booker-Feldman analysis prevents a reliable analysis of the probate exception to federal jurisdiction. If the complaint was not going to be dismissed as a shotgun pleading, it would be appropriate to take steps to identify and excise any claim covered by the probate exception to federal jurisdiction. And where have we seen this before? RICO, count 1 of the Third Amendment complaint asserts a claim under the federal racketeer influence. The other counts arise under state law. There is no diversity of citizenship, so those counts are within the court's supplemental jurisdiction only. And again, we've seen this before. We just read this earlier today. To prevail on such an action, a plaintiff must plausibly allege 6 elements that the defendants operated, managed an enterprise through a pattern of racketeering activity that included at least through two predicated acts of racketeering, cause injury. Yeah, we already read all that. Overarching issues, we read all that before. And I'm skipping over this. If you're wondering where the rest of it is, all of that was in a prior one. Capacity of the plaintiffs. The complainants asserts claims for 3 plaintiffs, Victor's 3 daughters, in various capacities. True to its shotgun pleading character, the complaint is less than clear on this. It lists Geraldine both individual and as beneficiary without saying beneficiary of what? That's funny. In the parties section, the complaint describes her as personal representative of Victor's estate and beneficiary of the trust. It lists Denisha both individually and as personal representatives. Parties section identifies Denisha as personal representative of his estate. Neither the case style nor parties section identifies Denisha as a beneficiary of either of Victor's estate or of the trust. His phone fingers went, yeah, but thank you. I'm okay. Maybe not. The case style lists Vicky only as individuals. Party section does not refer to any of the 3 plaintiffs in any other capacities included individually. But the descriptions of the plaintiffs in individual counts do not match the description in the case style and party section. The identity and capacity of the plaintiffs matters for count 1 because under proper plaintiff is any person injured in his business or property by a RICO violation. It includes individual, entity, beneficial interest in the property. Only damage the plaintiffs seem to allege is a loss of potential inheritance, or perhaps a loss of a right to trust assets, though the complaint does not allege facts showing how the trust assets would devolve to them. Under Florida law, a future inheritance is not a property interest. Say that again. Under Florida law, a future inheritance is not a property interest. And even if the state law characterization is not controlling for purposes of it, it is clear that any claim for depletion of his assets prior to his death for depletion of his estate must be brought by a personal representative, not by the individual heirs on their own behalf. See, these are state laws that they already have in place to protect people from this kind of shenanigans. Because what happens to somebody that lives in New York? One of my friends told me this, great Jewish guy. He said they all go to Florida to die. And that is known. You know, you're living in a cold state, New York, New Jersey, Boston, you know, whatever. And you're just like, you know what? I'm going to retire to Florida. Whenever I can retire, I'm going to retire to Florida. You retire whenever you're 65. You're down there for 10 years. You're hitting 75. Another 10 years, you're hitting 85. Another 10 years, 95. That's 3 decades of knees going out, of back going out. That money gets depleted. It's going to get depleted highly in Florida. Why? Because you got a lot of freaking old people there. If the RICO claim could go forward at all, plaintiff's capacities would have been properly defined. explaining that a person is entitled to recover under RICO only to the extent the person has been injured in the person's business or property. And we're not going to go into enterprise because it just gives a definition of what it is. The court held that the plaintiff failed to adequately allege an enterprise or racketeering activity. So basically, they couldn't even prove. I'm not sure about New York, but what happens in Vegas, well, it always stays in Vegas. I thought you were not supposed to tell anybody, Yamaha. What is wrong with you? You know better. You know better than that. An abstract common purpose. An abstract common purpose, such as generally shared interest in making money, will not suffice. Let me say that again. An abstract common purpose, such as generally shared interest in making money, is not going to suffice. Observing that the common purpose of making money is not sufficient to find an association, in fact, between an airline and outside vendors that provided supportive services. Rather, where participants' ultimate purpose is to make money for themselves, a RICO plaintiff must plausibly allege that the participants shared in the purpose of enriching themselves through a particular criminal course of conduct. Sounds familiar, doesn't it? Unblock people that were blocked because I do carry my phone in my pocket a lot. Well, it happens, Wicked. It happens. Thus, the plaintiff needed to allege facts that plausibly supported the inference that the defendants were collectively trying to make money in pet sales by fraud, which is a common purpose sufficient to find RICO enterprise. Same defects noted in Cicerno's enterprise allegations are present here. The complaint alleges an enterprise included 4 interconnected subgroups: elder law attorneys, assisted living facilities, healthcare providers, real estate investors. The complaint alleges the defendants had a unified objective of extracting financial resources from elderly victims through calculated legal and medical strategies. But as Cicerone explains, it is not sufficient to allege that a group of people were collectively trying to make money. Instead, there must be sufficient factual allegations that the defendants were collectively trying to make money by fraud. And if you want me to explain that a little bit, they could have gone after Luthman and his cohorts for RICO violations, okay? Because their scam was defrauding people with the intention of making money, okay? Here, as in Cisneros, the complaint has insufficient factual allegations of fraud. Here in Cisneros, they are sweeping general and conclusory allegations of fraud, but no allegations of fact constituting actual fraud. In the most general way, the complaint alleges double or triple billing, but the defendants that are medical providers and nursing facilities apparently provided the services they billed for. The plaintiffs do not assert the contrary. Indeed, they admit Victor lived in the nursing home facilities. Similarly, the plaintiffs do not deny that Ms. Sketchley provided actual legal services. The entities involved in the sale of Victor's residence provided the actual services, and the residence was sold. There are no allegations suggesting they participated in any fraud or even that any fraud occurred. What they're trying to complain is that's about a different case as Doritos had. Now I finally understand. This is about a different case that Doritos had. Yeah, that's what I said earlier, Sherry. A completely different case. The lack of factual allegations of fraud is even more stark for these particular people. TMH apparently has been sued only because Katz is credentialed there. It alleges that Katz treated Victor not at TMH but at FSU Senior Health. The complaint failed to adequately allege an enterprise and thus failed to state a claim on which it can be granted. The same is true here. Now, in addition, They must function as a continuing unit, which means they have to be doing this on a regular basis. An enterprise does not have to have a formal hierarchical stature, but parallel conduct alone cannot support a plausible inference of an agreement. It alleges conclusory and subgroups were interconnected, but no allegations of fact supporting the conclusion. At most, defendants were engaged in parallel conduct. And the reason that I'm bringing this up is because this right here is being brought up because this is showing the kind of filings that will get your shit kicked out of a court in a freaking heartbeat. They do not like this. They do not tolerate this. Courts don't like seeing this kind of attitude whenever you're filing a case. This is why you want to have a competent attorney come in and actually file this kind of stuff. Here, the complaint refers to fraud, Hobbs Act robbery, and obstruction of justice as predicate acts, but there's no apparent basis at all for the reference to Hobbs Act robbery, obstruction of justice. The RICO claim depends on allegations of fraud. Just want to double check and make sure that this Cicero's 2 alleged racketeering activity was fraud. After holding the plaintiff failed to adequately plead an enterprise, the 11th Circuit held further that the plaintiff failed to plead with particularity the pattern of, being a fuckhead. Under the well-settled law of the circuit, a fraud plaintiff must plead precisely what false or fraudulent statement was made. The time, the place, and person responsible for the statement, the content and manner in which the statement misled the plaintiff, and what the defendant gained from the fraud. The plaintiff failed to meet that standard. The court said that blending the identities of the defendants in the allegations of fraud is precisely the kind of vagueness in fraud pleadings was designed to prevent. Court said it would not scour the allegations of a complaint to link unnamed defendants to particular acts or fraud without some reason or plausible way to do so. And this is the bad part about it, is whenever you file something that has a bunch of shit in there, like a bunch of absolute garbage in that filing, and you're telling them, well, go find where they did it. It's right there in black and white. It's like telling someone to Google something. It's insulting. Well, they did such and such. Just Google it. No, show me the proof. This is a weak argument. Plaintiffs failed to plead the predicate acts, the alleged fraud with the required specificity. The allegations are general and conclusory, as in Cicero's. The identities of the defendants are blended. For example, they alleges the enterprise, in all caps, bolded but not clearly defined, constantly engaged in a pattern of criminal activities over a decade, demonstrating mail fraud through unauthorized mail redirection, wire fraud via manipulated medical records and billing, healthcare fraud through unnecessary medical services, financial exploitation of vulnerable adults, kickbacks for referring within network capitalized with no definition, and systematic property seizure under market real estate transactions. Yeah, this is like reading a conspiracy theory. Okay? If you've ever heard anybody that talks about conspiracy theories, or they have conspiracy theories, they use the same kind of language without any specificity to any particular act. They just say, well, they're constantly engaging in it. Well, and here's the documentation. You find it. Okay, that's not good enough. And this comes nowhere close to Rule 9b, particularity standard. So, whenever you see these people that are talking about, wanting to get certain laws changed, for example, and, you want to have them actually being able to plead, in this case right here, Miss Jones, she lost X, Y, and Z because this, and this happened. And here's the proof when this, and this happened. Sounds familiar, doesn't it? Operating or managing the enterprise. And I'm not going to go into that one because it's boring. Sorry. And it's basically just saying that the complaint does not meet this requirement. Even if the complaint were deemed sufficient to allege a given defendant profited from the enterprise, the complaint does not allege what the defendant did with the money, how the defendant used the money in an enterprise or invested it in that said enterprise. Irrelevant part makes it unlawful to acquire or maintain an interest in or control an enterprise through a pattern of racketeering activity. The complaint alleges the plaintiffs were injured by fraud, but the predicate acts, the complaint does not allege any injury from a defendant's acquisition or maintenance of the enterprise. And then another section, in relevant part, it makes it unlawful to conduct or participate in this. And the claim fails because the complaint does not adequately allege a pattern of racketeering activity. And the same way with 62B, is that right? 1962D, same way, two ways. Here, the complaint does not adequately allege RICO conspiracy. Some of the deficiencies are noted above, and there's no factual allegation suggesting any defendant agreed to an overall objective of a conspiracy. State law claims. We're already to X. That's a lot of damn numbers we're going through. I keep looking for the blue buckets. Well, if you blink really fast, you'll see them. If the entire action was not dismissed on shotgun pleading grounds, the federal RICO claim would be dismissed for failure to state a claim on which it can be granted. Conclusion. We're down to page 49. The conclusion of all of this. And then we have a letter right after this. The third amended complaint is an egregious shotgun pleading. The plaintiffs filed the pleading in that form despite a clear warning of the governing standards and the requirement to comply with them, which we showed at the beginning of the stream here. The governing standards and the requirement to comply with them, a possible explanation is that the plaintiffs simply do not have a factual basis for their claims and thus must set them out in general, conclusory language without clear organization. The better to mask the lack of factual basis for the claims. Let me read that again. A possible explanation is they simply do not have a factual basis for their claims and must set them out in general language without any sort of clear organization to mask the lack of basis, factual basis for the claims. But whatever the explanation, the plaintiffs cannot proceed acting like the fools that they are, or in this manner. The plaintiffs could be given leave to try yet once again. Max Lab's almost there. Phrasing. But as a matter of discretion, I chose not to do that because it seems clear that some of these defendants should not have been sued at all. And it seems likely that affording the plaintiffs another opportunity to amend would just increase the cost of the litigation, otherwise accomplish nothing. Other words, you're looking for a cabal that's not there. And had the plaintiffs been able to allege actual facts showing a RICO violation or other basis for recovery, well, damn it, they should have just alleged the facts in the third amended complaint. And they had fair warning. And so it's ordered. The motion to dismiss 36, 41, 52, 54, 55, 56, 62, 68, 70, and 71 are granted. And based on that motion, those motions, and on the court's own motion, the third amending complaint is dismissed with prejudice, which means this case If not for the dismissal with prejudice on the basis, count one would be dismissed with prejudice for failure to state a claim on which it could be granted, and all the rest of the bullshit that you filed would have been dismissed based on the discretion not to exercise supplemental jurisdiction over them. And this clerk, they must enter the judgment, close the file. So ordered on June 4th, 2025. Now, they do have the option of appealing this, but like I said, there's a high standard for them to actually get that pleading in. There's a very high standard for that, and that right there is what they haven't met yet. Now, whenever they file it with the court's going to look at this and see if there's anything appealable. Sometimes you can't even argue in front of the appeal. They will take one look at the case and they may just say, judge's order was pretty fucking clear. Denied. So many bad lawyers. Yeah, there are some bad lawyers, and there's actually some really good attorneys out there. And there's some pretty damn smart attorneys out there. And you got some pretty smart attorneys that can be bad. And you've got some pretty bad attorneys that can be pretty smart. I feel for the Doritos client, he screwed the pooch for them. Well, you can only screw the pooch so many times before, something drastic happens. Yes, you heard correctly. That is Yamaha. And yes, they are appealing. But that's the thing. Like I said before, whenever you file an appeal, there's steps that you have to take to get that in front of the judges for an appeal. Usually, if I'm not mistaken, it's a board, like maybe like 3 or 4 judges, something like that. And they will actually look at it and decide whether they want to take that up on appeal. And they can kick it back if it looks like it's just like it doesn't stand any chance. Like that's why they, even if they send it up for appeal, the appellate court doesn't have to take it in.
Right.
They can just look at it and go, yeah, the judge hit it right on the head. There's nothing that the judge didn't put in here that is inappropriate. And so they won't even hear it.
Well, and that apparently is what the head useless turd is running her cockwasher about too, and getting all up in arms. And but nobody's talking about how it's up for appeal. That doesn't mean shit. So what?
Yeah, it
doesn't mean
anything.
A fucking thing. She just wants to set aside this ass reaming that he got. Fuck him and fuck them.
Yeah. Well, I've got a beautiful response.
She doesn't know her ass from a hole in the ground anyway. So. What
she has an ass? I mean, I don't know. I mean, I just figured she just.
That's why it leaves a pretty big hole in the ground. You can't tell.
You're killing me, y'all. Killing me, brother. Oh no! What I've got, because I heard all of these gobbledygook of what people were saying, and they seem to think that mocking a bad filing is attack on victims. It's an attack on an attorney. It's an attack. It's harassment. It's giving them a hard time. Why would you do such a thing?
No, it's not.
Why would you file something stupid? And that's what my letter is about tonight. Are you ready? You feeling that?
Oh,
you feeling
sure.
The pressure? Is it going to pinch?
I gargled and stretched my throat all out. Oh, yeah.
I'm going to leave you laughing.
I put it through
brother.
the ringer.
You're going to be laughing when you read this.
Okay. You're setting the bar high.
Oh, it's so good. I had so much fun with this one today.
It's the audience out there, and that's what I enjoy. I enjoy seeing their reactions.
Yes, an
When
audience.
I go back and
You have to respond to him
rewatch.
because he'll go back and he'll watch the chat. He'll see exactly what you were saying.
I do.
So you give Yamaha hell because he's gonna piss himself whenever he reads it.
It is about time. Let's break this mother down. With Shizzywhiznut.
Yes.
An open letter to whatever moron thinks that mocking a bad filing is an attack. Dear morons, let's set the record straight, since apparently some of you still don't know how courts or criticism work. If you file something in public court, especially an appeal, you do not get to throw a tantrum when someone reads it, understands it, and mocks it for being legally incompetent. That's not harassment, and it's not attacking survivors. It's what happens when you dress up incoherence as jurisprudence and submit it for public consumption. You invited scrutiny the second you took your sealed filing and launched it into public record with the same grace as a raccoon in a law library. Or a monkey throwing shit at a wall.
Yes.
Here's the distinction that your bad faith outrage conveniently glosses over. No one is talking about the underlying case. Why? Well, because it's sealed, as it should be. No one is combing through private trauma.
No.
No one's debating what isn't public. What's being critiqued is the appeal, the one you filed, in a court of law, in plain view of the public, with citations that fell apart faster than your credibility. Like a bum taking a dump in the middle of a public park. If you're incapable of understanding the difference between private subject matter and public legal filings, maybe the courtroom isn't the sandbox you should be playing in.
Or shitting in.
Yeah, I was just going to say, those damn cats in my rocks. Okay. If you file an appeal that was logically bankrupt, procedurally flawed, and intellectually insulting, why should anyone be worried about your feelings? Because as I said, reality in the courts nor I give a fuck about your feelings. The court said as much, directly, and without a hint of hesitation. And now that people are pointing out how thoroughly your arguments were dismantled, you're running around crying. You don't understand the real case. As if that erases the fact that you got smacked down in open court with a ruling anyone can read. Well, that's how appeals work. That's not how reason works. That's just weaponized emotion with a header and a footer. And let's be honest. The reason nobody wants to debate you is because, well, in reality, you, number one, don't matter. And you don't come to the table in good faith. Your existence is pretty much irrelevant. You don't argue the merits. You don't engage with ruling. You cherry pick what helps you, ignore what hurts you, and drag in emotional landmines when your filings can't stand on their own, and then cry when they blow up in your face. You turned sealed allegations into PR campaigns and then scream about privacy when your public filings get mocked. No, you demand seriousness, but submit bullshit trash. You posture like a principled advocate, or like a baboon that's in heat. But the second your narrative gets challenged, you retreat behind deflection, outrage, and a victim complex so oversized it should be filed as a separate docket entry. You file like an ignoramus, argue like an amateur, and then act like a martyr when the results reflected that. And you are no Joan of Arc. Your appeal wasn't dismissed because people are mean. It was dismissed because it was bullshit, trash, garbage. And everyone in the courtroom, including the judge, saw it. This isn't about attacking the private contents of sealed case. It's about asking a basic question. How did something this incoherent make it past a clerk's desk, much less reach a federal appellate court? You want deference. You want people to whisper, tiptoe, walk on eggshells, and treat your filings or feelings like it came down from the mountaintop. No, but it didn't. It came from a place of entitlement, arrogance, and the bottom of my shitter, and the assumption that nobody will dare call it what it is. Bad law, bad strategy, and a desperate attempt to rehabilitate a narrative that's crumbling under the weight of its own contradictions, much like your broke-dick chair. When someone like me points that out, not by guessing, but by reading your own words, you scream, foul, and that's just not because of your Fermundices. Weaponized sealed records you claimed you wouldn't discuss, and pretend the criticism is some kind of moral violation. It's not. It's just fact-checking, and your paperwork failed the test. So no, I'm not going to stay silent. I'm not going to pretend your filings were noble, or that your appeal was coherent, just because the original case was sealed. You opened the door to your public analysis the moment you made your loss everyone's business. The court didn't buy your bullshit, your reasoning, and neither do I. You lost, not because the system is unfair, but because you didn't know what the fuck you were doing, and you assumed the seal on the original case would immunize you from consequences. No, it didn't. Which is why Lips wants everything sealed, because it just makes her stupidity even that much more glorious.
Yes.
Here's your reality check. No one mocked what's private. We mocked what's public, because it deserved to be mocked. And if you can't handle that, stop filing. Stop shitting all over the place and then blaming everyone else. Stop pretending that public records are sacred until they don't serve you. Stop crying harassment when what you are getting is deserved skepticism and a mirror held up to your own incompetence. No, you can't hide behind the seriousness of the original case to protect the unserious way you handled the appeal. If you want people to take you seriously, show up with arguments, not theatrics. Show up with law, not lore. Because right now, all you're doing is proving that the court's dismissal wasn't just appropriate, it was merciful. You filed. You lost. You appealed. You lost again. And now you're angry that someone pointed out what the court already confirmed. Your argument wasn't just weak. It was embarrassing. That's not bullying. That's the natural consequence of pretending bad legal work deserves a standing ovation. But let me guess. Now we've entered the feelings portion of the meltdown, right? Where facts are mean, rulings are biased, and anyone who reads your public paperwork out loud is suddenly practicing law. Oh, practicing law without a license. I'm not going to call her honey. Oh, shitbag. Sit your ass down, you clown. Commentary isn't lawyering, and deep down, you already know that. You just hate that the commentary is more coherent than your actual bullshit babbling and filings. See, you're not mad that people are pretending to be lawyers. You're mad because, well, you're not an attorney, number one. You're mad that non-lawyers read your public appeal and still knew it was hot garbage. That's what really stings, isn't it? You thought you could slap some citations onto a Word doc. Oh, wait a minute. This is Numbnuts. This isn't her. Oh,
no, it's not her.
Okay, well, he's still an attorney. Never mind.
Yeah, he's an attorney.
Yeah, all right. I retract it. Sorry. Not sorry. Anyway, whatever. That's what really stings, isn't it? You thought you could slap some citations onto a Word doc, sprinkling buzzwords like reversible error and manifest injustice. I'm just used to reading about her stupidity. And people would either be too dumb or too scared to challenge it. But then came the inconvenient truth. You didn't need a JD to see this train wreck. Just eyes, a brain, and a few minutes on Google. Mm-hmm. So now, instead of owning the loss like an adult, you've pivoted to the lowest hanging, weakest branch on the excuse tree. They're not even lawyers. As if that disqualifies. Oh, I should be reading it in a different voice. Ain't got no gas in it. They not even lawyers. As if that disqualifies anyone from commenting on public court filings. I really shouldn't do that. I think that's an insult to Carl.
Yeah, it would be.
Or quoting a judge's ruling verbatim. Oh, McFly, hello! Judicial opinions are not classified documents, and making fun of your footnote fail isn't unauthorized practice. It's just sport at this point. Like shooting blind ducks flopping around. You want to play in court, but hide behind private courtroom protection. You want to cite the First Amendment when it suits your narrative, but cry, unauthorized law practice. When someone uses the same rights to call your motion stupid and filed like a trash panda on caffeine. You want immunity from criticism, but unlimited power to make reckless filings and frame every critic as a threat to your sealed fairy tale. And I've read some very weird fairy tales.
Yes, you have.
The cognitive dissonance would be hilarious if it weren't so transparent. But let's be very clear. Reading your filings, laughing at your filing, quoting your filing, and then comparing it to a Taco Bell napkin is not legal practice. It's Tuesday. If the only way your legal argument survives is by silencing the commentary, then you don't have a legal argument. You have a PR campaign and a panic spiral. Well, and the funniest part, you know all of this. You're not confused. You're just hoping that if you throw enough emotional smoke bombs or shit at the wall, nobody will notice you walked into court swinging a pool noodle and called it a sword. Oh my God. Trial by combat. Trial by combat. Like some fat little paint chips. So go ahead. Keep pretending that criticism is malpractice. The commentary is criminal, and that your fragile little legal logic deserves a velvet robe. Just don't act surprised when the crowd, lawyers and non-lawyers alike, read your appeal, snort once, and say out loud what the court wrote on paper. Denied. With prejudice. And probably Advil. Oh my God. So, taken in suppository form. So here lies your appeal. Not so much a legal document as it was a conspiracy pamphlet in paragraph form, gift-wrapped in self-pity and duct tape to a half-melted procedural rule you clearly didn't read. You didn't submit a legal document. You submitted emergency shit paper, a vibes-based manifesto, desperately hoping the court would be too scared to say, ma'am, this is a Wendy's. Mm-hmm. You wanted to bypass scrutiny by wrapping your nonsense in something sealed, sacred, and conveniently unverifiable. You screamed, You can't criticize this. You don't know what really happened. But the court wasn't ruling on what might have happened in your sealed origin story. They were ruling on your very public appeal. And guess what? It wasn't dismissed because it lacked emotional resonance. It was dismissed because it lacked legal merit, structure, facts, and basic adult reasoning. Let's be real. If what you're clinging to is so explosive, so devastating, so court-shattering, that it would flip the whole system upside down, then show it. Like a bad version of, what was that? Oh, shit. Oh, I just fucked up my own joke. Never mind. God damn it. All right.
I know the movie.
Yeah, you know what I'm talking about. The Poseidon Adventure. There you go. Yeah. Oh, that would have worked. Oh, damn it.
Yes.
See, this is what I get for trying to do this shit on a cold read. File it. Argue it. Move it through discovery like every other functioning litigant in the federal system.
We do this with no lube.
Yeah. Because until then, it's not evidence. It's fan fiction with a heading. And until it appears in a court-approved record with actual substance and admissibility, it's not a legal argument. It's a bedtime story. No, it's not. It's horrible. No. It's a bedtime story for your donor base.
Like I said, horrible.
You know what happens when you file a real case? You get rulings based on law. You know what happens when you file a messy tantrum based on emotion? Oh, dressed up as a motion. Mm-hmm. You get exactly what you got. A panel of judges politely reminding you that sealed allegations don't excuse public stupidity. So, go ahead. Keep whispering about what's really going on behind the seal. Keep acting like everyone's just too afraid, too uninformed, or too cruel to understand your grand sealed truth. But know this. The only reason people aren't debating that part is because it's not legally up for debate. Not because we're scared of it, but because you haven't put it on the table. You've stapled a conspiracy to a pleading and expected immunity from criticism. Like you're Martin Luther with the 95 Theses. Here's a tip. If you want to be taken seriously, stop filing like you're trying to win a TikTok sympathy edit and start filing like someone who understands what jurisdiction means. Because until then, you're not changing the world. You're just wasting the court's time and daring people, like me, to read it out loud and laugh. And, I will laugh loudly, often, and on repeat. Because the moment you take the mess to the public docket, it's fair game, sweetheart. I don't need to be a lawyer to quote what a judge already ruled. No. I don't need a license to recognize that injustice doesn't mean, they didn't believe me. And I sure as hell don't need your permission to roast an appeal that collapsed harder than your filing strategy. You wanted attention, just like your dumbass wife. You got it. You wanted control over the narrative. Well, you lost it, just like your dumbass wife. You wanted reverence for a document that reads like a Reddit rant, and you got roasted by both the court and the court of public opinion. So go ahead. Keep pretending I'm the problem. I'll be over here, reading the next dumpster fire you file. Bag of popcorn in one hand, and a fire extinguisher or my hoo-ha in the other. Pissing all over it. The guy who lit the match, stoked the flames, and brought Extra Charcoal, a.k.a. Shizzywhiznut, certified public menace, unlicensed legal critic, and full-time translator of bullshit into plain English, still wearing Velcro shoes, still not sorry, and still quoting filings word for word, because mockery is easier than when punchlines write themselves. And unlike your wife, oh yeah, I'm your daddy, bitch.
It is about time. Let's break this mother down. With Shizzywhiznut.
Great letter. Yes, it was.
It was good.
It was.
It was good.
Right.
Clubs at my own damn jokes. That's all right. That happens. Whatever.
Oh, I had to go and take a couple of spicy things out of there, but
Yeah.
other than that, it pretty much wrote itself, because I heard these people saying, "Oh, you're not a lawyer, you can't read court documents." I'm like, what the fuck are you talking about?
Yeah. They're still
Anybody
banging
can
away
read
on
court
that.
documents.
When she came over there and dropped her version of the 95 thesis on your stream, humping your leg, and she had made reference to that a couple of times on her little fucking ranting in there about that. And it's like, get the fuck out of here. Who are you kidding? No,
not how
not.
this works.
Jesus, no,
Like,
it's not.
if you don't like it, then don't fucking file something stupid.
Yeah, exactly. And that's exactly what it is. They're a bunch of feelings-based, soy-dripping fucktards.
Yes.
That's exactly what it all comes down to. They can say and do it, and it's fine. But anybody else that does,
Oh, you're not qualified.
Then,
You're not qualified attorney. How dare you? You're not
it's all
qualified
about
to read
harassment
this.
and bullying and blah, blah, blah.
Like,
Well,
what
I
are
don't
you
give a
talking
fuck what
about?
they think.
You don't have to be
Just fucking-
qualified for anything to read a court document.
Right. Yeah.
People do it all the time. And thank you very much. Objection: too much hilarity in one reading. Sustained. I haven't seen this much legal chaos since Law and Order blooper reel.
Right? Yeah.
Oh,
Yeah.
and of course, Nana Misty has been here for 6 months. And I just got to say,
Welcome to the shit show.
every single day, a new flavor of fuckery, 'cause everybody sucks, you see, and they're dumber than a bag of rocks. Monday, Tuesday, Wednesday, and then 4 more days of increasingly stupid, ridiculous, ignorant, balderdash, poppycock, bollocks, and fuckery. We're all over again. You just said it's a federal offense. Well,
Yeah. Like I said, that
Yeah,
dumb bitch doesn't
right.
know her ass from a hole in the ground.
it's a federal offense. No, it's not, dumbass. That's not how it works. These people, they just don't. They don't have a clue, and I don't even care. That's the thing. It's like, I really don't care. It's the misinformed that whenever they find out, they'll go, oh, yeah, I guess that's not true. But it's not about that. See, the reason that they say this kind of shit is because they want people to go over and see what the next stupid thing they're going to fucking say is.
Right. Well, it's
It's as
like
simple as that.
it's right, and it's like going back to what we were saying before, where they don't want to sit there and talk about and point out how he got his ass reamed in this whole thing. They just apparently want to sit there and keep screaming about, oh, but it's up for appeal. It's up for appeal. That doesn't mean shit. And just like when Bubbles would go over there and just highlight certain, oh, don't read this, don't read, oh, just read what's highlighted. Just read what's highlighted. Yeah, because you want to cherry pick and try and point shit out that fits your fucking narrative instead of reading the
Exactly.
whole fucking thing. Footnotes and all.
Yeah. And I mean, it's not hard to do. Unless you're filing 135 pages of fucking gobbledygook, then yeah, it's difficult to fucking read. But I mean, you do a fucking 8-hour stream bitching about somebody that you don't fucking like, saying that you're not going to be bitching about them.
Exactly. Yeah. Yeah. Hello.
It's like, wait.
Yeah.
Oh my gosh, what is it? Did that work? That didn't work.
Yeah. Oh no, we got you talking about the thunder
Something
and light?
happened.
Yeah.
I don't know. Did you not hear that?
Oh, we got your thunder. I heard it.
Audio. I think my audio went. Oh, it did hit it. Did you hear it?
Yeah.
Okay.
The thunder. I heard it.
There we go. I didn't hear it.
Welcome to the shit show.
Oh, Gutter's Pub.
Every single day.
Almost enough time here for 2 babies.
A new
Well,
flavor of fuckery. Cause
Gutter's
everybody's
Pub.
such you see, and they're dumber than a bag of clots.
I'm
Monday,
married.
Tuesday, Wednesday,
My wife might object.
and then 4 more days of increasingly stupid,
think your husband might object, too.
ignorant, boulder, dash, poppycock,
so much Gutter's
bottles,
Pub.
and fuckery. Yeah, live it all over again.
Shizzy is reading a court public document. It's not illegal to read a public court documents. Anyone can get them. Yes.
Yeah.
And Shizzywhiznut for real. She wants to be noticed and watched at the center of attention, but she's not at all any of those. Any of those what? I don't know what that is, but whatever it is, sure.
No, well, because she's not actually the center of attention.
No.
Yeah, she's not getting,
No, she doesn't have the skills for that.
She thinks all the shit that dribbles out of her mouth is golden. No, it's just shit.
No, I guarantee the shit that dribbles out of my mouth is just that shit that dribbles out of my mouth. Fleece is an idiot. She also thinks Doritos is a brilliant attorney and makes $500 an hour.
Yeah, but they said the same thing about paint chips and bubbles too. So.
Yeah, I mean,
So,
I guess they have this obsession thinking that attorneys should be charging $500 an hour because that makes them special or something like that. Let me tell you a little bit of something about attorneys here. Okay, attorneys charge what would be normal. Okay, and their field, their particular specialty, how long they've been practicing in that specialty, where they practice at, has a lot to do with it also. It's the same way with doctors. Doctors charge, like your local, doctor in a small town, in
family
somewhere
GP.
in Kentucky, a family practice. His father was a doctor before him. He has 50 or 60 clients. He can't really go and charge them, a doctor in the big city.
plastic surgeon in Hollywood or some shit.
Exactly.
Yeah.
A plastic surgeon in Hollywood, he's still a doctor, but he's going to charge a lot more. It's a very specialized field. And it's the same way with attorneys. The more specialized you are in a field, the higher that you can charge for that specialization because you do it and you do it well. But it's also comparable to what other attorneys are doing. Because let's put it this way. If you go to an attorney, he's specialized in that field, and you go, well, this guy right here is going to charge $6,000 an hour. He's specialized in the field. And I got this other guy that charges $250 an hour in the same field. Which one are you going to go to? Are you going to go to this guy that charges the same amount for the exact same service? It's probably not. It becomes a financial burden on you. Well, I'm not going to do that. I mean, and also whenever you're asking for court fees, for example, you can't sit there and say, oh, you can't inflate your amount. You can say, listen, I worked on this particular case for this amount of hours. This is what the standard fees are for an attorney, and this is what I should be compensated for. If you come back and everybody's going, dude, even a judge knows, they'll say, no, all the lawyers in this particular field of work, they get paid, $250, $350, $400, $500, $750. It doesn't matter. Whatever the prices be, whatever the going rate is, your prices have to be comparable to that. Judges won't play with your bullshit like that.
Well, it also depends on the standing. I mean, you're not going to get somebody like fucking Federigos here, paint chips or bubbles, and even if it was the same, say they were on the same board with the same expertise or specialty, and they're not going to be on par with like an F. Lee Bailey.
Oh, no.
In what they're going to charge because of his demand. And even though he's going to be a hell of a lot more expensive, there are a lot of people out there that will pay that expense because of his expertise and because of his experience. And
also, he doesn't take on as many cases. You know, he's not going to be taking on he's going to be taking on an O.J. Simpson, but he's not going to be taking on Lynette Preston.
Right.
Because you'd be like, what? No. They could be the same case. But he's going to go, no, I'm not taking your case on. I mean, you're filing indigent. I mean, I might do it pro bono, but that's about it. You know, I'm not going to deal with it. Later, Kippy, you have a good one.
Yeah.
Wonder what Karen Reed's lawyers charge per hour. Karen Reed's lawyers, probably comparable to whatever anybody else is charging in that area. I mean, they're not going to overinflate their rates for that kind of stuff. I mean, it could be anywhere in that area. It could be anywhere from, you know, $400 an hour to, you know,
but then it's also everything else that goes into it from coming out from California.
Right.
So travel, lodging, all of that goes into it too.
Exactly. And sometimes they charge a flat rate for trial.
Or they may charge,
like per day. They may say, you know, it's going to be $2,000 per day.
Yeah.
You know, because they're in the court and then, you know, they're just sitting there waiting. So, you know, they sometimes will like do a basic thing, because if you're paying someone to be sitting there for 8 hours a day, you don't want them trying to rush through it. So they're going to base the rates on whatever it is for trial days, especially if you've got a 2-week trial. I mean, you'll run into the millions in a short period of time if you're charging by the hour. You know, 8 hours a day, and then you've got 4 attorneys and you've got, you know, 3 or 4 paralegals, and just like, no, you're talking that just gets ridiculous unless he charges over $4K an hour. Okay. I don't know. I mean, it just depends on the kind of work. It may only take them an hour to do whatever work that they do. I had an interview this morning and that's what he said. I don't know.
Vicky said that Jackson said that he wasn't going to be charging Karen Reed. So,
Let's see.
I don't know. Okay.
I mean, it could be any number of things. I don't know. I don't worry about what an attorney costs.
No.
Does it? Because it doesn't matter to me.
No.
You know? Why would it?
No.
Well, everyone, it is that time of night. I'm going to send you guys off with a fresh good night, and I will see you guys in the morning. I'll have a lovely stream in the morning. It's going to be pretty chill. It'd be Wednesday, which means Wednesday night I will be over with Mo in the deep end, and Wednesday night with Mo in the deep end, going over some more Coat Burger. Should be fun. I can't wait. I'll see you guys in the morning.
See you later.
Later.
Bye.
Oh, you thought I was done, bless your heart, but I'm still living rent-free, it's a work of art. Call me daddy, call me nut, call me the goat. You're paddling upstream while I'm running this boat. You say, I don't care, yet you're glued to the screen. Caught up in my glow while you stay unseen. Your shade's like a breeze, it's barely a draft. Meanwhile, I'm the Picasso of roasting your ass. You say you're over me, oh how cute, but here I am, still the star of your loop. You're my biggest fans, don't even deny. So grab some popcorn when daddy goes live. Live. Call me daddy, yeah, shout it loud. King of your thoughts, I'm making you proud. Papa Nut, Shizzy Daddy, headline act. Your background noise, and that's just a fact. Let's face the score. You hate that you love me, but you keep wanting more. You're like a dog chasing cars, you don't know why. But here you are, barking while I touch the sky. wait, it's me, I'm told. You're keeping tabs like an unpaid intern while I'm cashing checks. When will you learn? Your timeline's a shrine to every move I make. I'd say thanks, but you're a nasty skank. Oh, Shizzy's washed up. Yeah, sure, Jan, yet here I am, the centerpiece of your plan. You hate watch my stream like it's Oscar night, but guess what, kiddos? I'm still shining bright. Call me daddy. Send in your bread. I'm still rent-free in your effing head. Papa Nut, Shizzy Daddy on your brain. I'm your mental landlord, you can't complain. Let's keep it real. You hate that I'm winning, but you love how it feels. Oh, I'm sorry, did I break your streak? You tried to ignore me for like half a week, but Daddy's too spicy, you can't look away. I'm the train wreck you need every single day. So while you're out there with your plastic clout, I'm here sipping coffee watching you freak out. You're irrelevant. Wow, what a take. Now go rewatch my vids while I count how much I make. I count how much I make. Call me daddy. Yeah, own it now. I'm reading your brain and you don't know how. Papa Nut, Shizzy Daddy, let's at the bar. I'm the constellation, you're a burned out star. Embrace your role, cause I'm the main character. You're just an old ragged ass burned out troll. So that's your bedtime story, kids tucked in sweet and snug. Shizzy Daddy's forever, you lose and you're stuck in the mud. Now say goodnight to Papa Nut, your mental pain. Oh wait, you will see me tomorrow's. Agenda will see me tomorrow, same obsession, same effing thing.
All right, everybody, go give